Good afternoon, everyone. Welcome to the Appellate Division, First Department. This afternoon, we have some 5.5 hours of argument time that has been requested, so please keep that in mind as I call the calendar. Remember that we have your briefs, we have the record, we're fully familiar with the facts of your cases, so ask only for the time that you'll need to make your most important points. People versus Jason Wright. Seven, 2, and 7. Lasher versus New York City Department of Education. Submitted. Berlin, B. Berlin. Submitted. Tsai versus Mega Life and Health Insurance. Do you wish to submit? Okay, I'll take a submission. Thank you. Donnelly versus Donnelly. Submitted. People versus Roger Almeida. Five, 2, and 5. Thank you. Rome Capital versus Asia Alternatives. Is there someone else here? Is the respondent here? Oh, I would have been surprised if they weren't, but no one was standing. So, okay, you said 7. Okay, granted. 8. 7, 3, and 8. Thank you. Piana Forte versus Nisha. 5, 2, and 5. Nunez de Rivera versus 3051 Fulton. Is there a cross appeal here? I don't believe so. No, so that's 3. 5, 2, and 3. You said 3 and 1, I thought. But there's no cross appeal. So then it's only 3 minutes. Izaki versus Izaki.
Respondent being Izaki, 7, and for respondent Rockledge Properties, 1 minute.
5, 2, 5, and 1. Thank you. People versus Sean Dyer. 5, 2, and 5. U.S. Bank Trust versus Chung. 5, 1, and 5. Thank you. National Union versus Razuk is submitted. Brathwaite versus Francois, submitted. Domingo versus 541 Operating Corp, submitted. Cedeno versus 155 West 162nd is submitted. First case for argument is People versus Jason Wright.
Good afternoon. May it please the court. Matthew Bova for Mr. Wright. There was no independent source here. As the Supreme Court held in Manson versus Brathwaite, the touchstone, the linchpin of the independent source analysis is reliability. And here, this record confirms ironclad evidence that the in-court identification of Mr. Wright was unreliable. And we know that because there was a scientific experiment conducted on this record effectively as to reliability. There was a lineup, a fair, objective lineup, 6 men, the The witness looks straight at it after a couple days after the incident and does not select Mr. Wright.
So why can't there be independent source? The court held a hearing, the witness was very detailed in her explanation, in her description. The court explained that she seemed to be a very, I can't remember the word, but particularly focused witness. Why wasn't independent source established here?
So the generic factors such as opportunity to view, those don't have any probative value when held up against the direct evidence of unreliability, which is the failure to identify. Factors such as, at the lineup, factors such as opportunity to view, those factors kind of are proxies for the possibility of a reliable identification. They don't prove a reliable identification. They pave the way for the possibility. But here, we don't have to worry about possibilities because we have direct objective evidence of reliability, which is
Counsel,
lineup.
if I may, the court had indicated that the surveillance footage corroborated the witness's detailed description as far as it related to clothing, the hairstyle, as well as the heavy build. Can you address that?
So first of all, we don't look at the record as a whole in terms of all the evidence to determine corroboration. That may bear on a harmless error analysis, but it doesn't bear on the independent source analysis. But as far as what we have here, we have a description with clothing. Now, where there is a description with clothing and a few minutes to look at someone, and then we put that person in a lineup and say, do you see the person there? And they say no. We know that whatever opportunity they had to view, that opportunity is translating into a non-identification of the person that the prosecution is putting
Well,
up.
let's talk about the opportunity because the conditions were bright, sunny. She certainly noticed the two, particularly when defendant walked towards the car 8 feet away. Certainly was also drawn her attention because of the fight. So what about that?
Because again, those are just factors that go to the opportunity to look at the individual. But then that generic factor is completely overridden by the lineup that is conducted. Because then we're testing that opportunity to view. And I think that's what our court system should be focusing on here. I mean, I think our system should not be focusing on proxies for reliability, the possibility of reliability. We have a record here that is testing accuracy. And that test fails as far as this witness because there's one objective fair process conducted here. Just one, and that's the lineup. And this witness does not identify Mr. Wright. But then, when there's the suggestive hallway identification, and when there's the in-court identification where Mr. Wright is the only person sitting at the defendant's chair, that's when the witness identifies Mr. Wright.
Sir, you mentioned a moment ago harmless error. Is the independent source issue subject to a harmless error analysis?
Generally, yes, but here the prosecution cannot show harmless error because this is the only eyewitness to identify Mr. Wright as the shooter. I mean, just as Justice Brennan famously said, there's nothing more powerful, there's nothing more convincing than putting a witness on the stand and saying, that is the man, that is the culprit.
So
all
even,
the other,
sorry, finish your sentence.
all the other witnesses presented at the trial do not identify Mr. Wright as the shooter. They put him at the scene. They put him in a confrontation, perhaps, but they don't prove that he is the one that fired the shots. And that's the critical issue in this case.
So even though this goes to confrontation, to the fairness of the lineup and identification, there is a harmless error review here?
Well, yes, it's constitutional harmless error analysis applies to the unconstitutional introduction of an in-court identification.
So we have another witness here, in addition to all of the other information. We had a witness, other than the witness who viewed the lineup, make an in-court identification. It was subject to cross-examination. Why isn't that enough? Why is the fact that this other identification, why does that undermine this conviction?
Because Fabre is the only witness to identify Mr. Wright as the shooter. I think Your Honor is referring to Joanne Imlay, but she does not identify Mr. Wright as the shooter. She is 100 feet away, and she says she sees a confrontation, but she does not see him pull the trigger. She actually testifies that she turns away, and that's when the shots are fired.
Does the person who's injured testify and identify him in the courtroom?
That's Joanne Imlay. Joanne Imlay testifies that she can identify him as being involved in a confrontation with Smith, but she does not testify that he is the shooter. She does not testify that she observed him pull the trigger. That's the critical issue in this case. And I think the prosecution introduced this testimony and took
One
the
question,
risk of putting
counsel.
a witness.
Doesn't Mr. Jacques Campin, doesn't he say that he saw the gunman firing and that gunman was approximately 30 feet away? Gunman was facing him?
But that witness does not identify Mr. Wright either. It is only Fabre that identifies Mr. Wright as the shooter. And that's the critical issue in this case. That's the whole case. So the reason why the prosecution risks putting a witness on the stand who previously failed to identify Mr. Wright in the lineup is precisely because the prosecution knows that there's a critical gap in her case.
Thank you.
In order to fill that gap, she brings in Fabre's identification. Thank you.
Thank you.
Good afternoon, Your Honors. Elizabeth Schmidt for the people. May it please the court.
Thank you. So, counsel, is there an independent source here, a viable independent source, when the witness identifies the defendant when he's cuffed and identifies the defendant when he's the only defendant sitting at counsel table, defense table, but can't identify the witness in a lineup specifically for the purpose of being able to focus on the defendant's face and be able to discern which person is the defendant?
Yes, Your Honor. I'll begin by pointing out that the purpose of an independent source hearing isn't to definitively determine if that witness can identify the defendant at a trial at all, but rather to examine whether or not that witness has an untainted independent source by which she can draw upon to identify the defendant. And that's the case here, Your Honor. As Your Honors pointed out earlier, the witness had an almost unparalleled ability to view the defendant for several minutes at a time under great...
So then what's the explanation for her not being able to identify him when the focus is on his face and his features at the ID?
Well, Your Honor, I'll begin by pointing out that contrary to counsel's assertion, the witness did give other descriptors of the defendant beyond just his clothing. While yes, she did give a very evocative description of his clothing, she did also note his weight, that he was quite heavy set. She gave an approximate idea of his height, which was a few inches off from his actual stature. And she described his hairstyle as well. She described it as something akin to very short and curly. So it wasn't just his clothing that she was drawn to. And of course, she was viewing him for several minutes from several different angles, beginning when he starts to fight with Kareem Smith and up until he's right in front of her car.
But she didn't make the identification at the lineup.
That's correct, Your Honor. And as for that, the cases that defendant cites in his reply brief are somewhat in a posit here, because there this court saw instances where a witness proves initially unable to identify a defendant in a lineup, given the opportunity to do so, doesn't do so. Then there's a subsequent improper procedure of some kind, which then prompts a positive identification of the defendant. And this is just in a different realm than those cases. For one, Faber did not have an opportunity to give an initial identification of the defendant before she inadvertently viewed him. And then she did not give a positive identification. And so if nothing else, you can say that was not police prompted.
Well, save for the encounter in the waiting area, how would you have known that she would identify the defendant as the culprit?
Again, I would draw on her excellent opportunity to view him, and at the independent source hearing, she did also remark upon the defendant's slightly changed appearance. She noted that his hairstyle had changed, that
Well, he was had completely shaven his head.
Yes.
So, I mean, that's a stark difference when someone has hair, and you know that the person who you were looking at has hair versus no hair. But it's different when he's in a lineup where there was no change, and she was looking at his face, and she couldn't make that determination. At the independent source, the focus was really on his clothing. She was very detailed with regard to his his clothing and his build and his movement, but not on the identifying facial features, which is how one usually identifies a person. Those are the one thing that we all are unique about, and that's the thing that she couldn't identify at the lineup.
Well, Your Honor, I'll also point out that all of these issues are credibility issues, and they were before the jury. Defense counsel got to cross-examine Faber about how she inadvertently viewed the defendant while he was handcuffed, and how she subsequently viewed a lineup that same day and did not identify him. So all of these issues were before the jury.
Except that if the independent source challenge had went against you, then you wouldn't have had the witness at trial identifying the defendant in the courtroom. So you were then armed with that in-court identification, and yes, there was cross-examination, but the point is that the witness shouldn't have been allowed to testify in the first place.
In that event, I would say at a minimum, this was certainly harmless error. To begin, there was a load of evidence, first of all, proving that the defendant was at the scene, which I can review, but beyond that, there was also plenty of evidence establishing that he was the shooter, and it certainly didn't hinge on Fannie Faber's testimony.
What was the temporal gap between the victim's witnessing of the dispute and the argument and when she was shot?
You're discussing Joan Imlay?
Yes.
I believe she said as she was turning, she was shot. I believe that's her testimony. So she said in the moment that she started to turn, it was defendant who was facing in her direction.
So she hears the dispute, she goes to turn, and then she
Yes, she thinks,
feels the
oh,
wound.
this is bad news, I'm going to start to go, and in that exact moment, she gets shot. And beyond that, too, two of the defendant's friends testified that he told them how he shot someone through his jacket using a gun. There were 911 callers who gave descriptions of defendants. There was video evidence showing Kareem Smith sprinting away from defendant while defendant's calmly walking after him. And I see my time is up, but if there are no further questions, we ask that you...
So there was video in addition, is what you're saying. There was video of the defendant where he could be identified leaving the scene. And
Yes.
then there was the Metro card that timed him leaving the scene and the time that he got back.
Yes, DNA evidence establishing his place at the scene, video evidence, his Metro card history, cell site evidence, it was all there.
Thank you.
Thank you.
But the critical issue is that the video evidence, as far as the harmless error question goes, does not show the shooter. It is Faber's identification that fills that critical gap in the prosecution's case.
But isn't that circumstantial evidence, that time gap between when Ms. Imre heard the dispute and then felt the gunshot wound? I mean, isn't that very powerful circumstantial evidence as to the identity of the shooter?
No, because it's not as if Mr. Wright is the only person there.
Well, I'm sorry, but doesn't the video show the clothing that he's wearing?
Yeah, yes, it does.
And didn't the witness who testified, Fannie Faber, wasn't she able to give in her independent source a very, very detailed description of the clothing the shooter was wearing?
But as for clothing, though, we
Your
have a
answer
description
is
of
yes?
it. Well, I think the answer is somewhere in the middle, because we have a description of a jacket and a shirt. And the probative value of that, as far as reliability goes, which, as the Supreme Court held, contrary to the state's suggestion otherwise, as the Supreme Court has held for almost 50 years now, reliability is the linchpin of the analysis. Descriptions of a shirt and clothing pale in comparison to the objective evidence we have in this case of the unreliability, which is the lineup. And I think the critical issue is,
Except I think when it matches the video.
well, but again, Your Honor, the video does not show the shooter. So we're not
But it
contesting.
shows the person who was testified as the shooter with the same exact clothing. So while she couldn't make a determination in the lineup of his face, the one thing that was never questioned and that the jury got to hear and they got to see was her description of his clothing and then the same person in the video.
But she's the one that is saying that the person with that clothing is Mr. Wright, he is the one that pulled the trigger. There's another person there involved in the confrontation, and that's Smith.
The one shot.
Sorry, Your Honor?
The one who shot. Is that who you're talking about? The other individual who was shot?
No, yes, Mr. Smith is involved in the confrontation, and the jury has to determine whether the identification of Mr. Wright as opposed to the other people there is correct, and it's Faber's ID that seals the deal for the prosecution.
Thank you. Thank you both.
Thank you.
People versus Roger Almeida.
Good afternoon, Your Honors. Ronald Zapata for Appellant Roger Almeida. The lower court
I'm going to just ask if you raise your voice a little bit, please.
Sure, no problem.
Thank you.
The lower court erred in assessing points for non-acceptance of responsibility based on allegations that were irrelevant to appellant's guilt to the offense to which he pleaded.
Do we have to reach that issue where the defendant absconded? He never appeared to register as a,
Oh, he did register for 5 years.
and then he absconded.
And it's questionable whether he absconded. It's the fugitive disentitlement doctrine. It's discretionary for this court to apply it. And first of all, it's questionable even if it can apply to this appeal when he's already completed his sentence in the case underlying here, and the absconding is based on a separate case. But
And I'm just going to ask you to keep your voice up and speak maybe a little slower.
okay.
Okay. So, but didn't he abscond in order to avoid reporting?
Well, the question with the doctrine is, like, there are a lot of factors for this court to consider with the doctrine. And so one of the major factors is about his voluntariness.
Can you just answer the question, is he back?
I'm sorry?
Is he back?
No.
So since December 1st of last year, when, December 6th, when he failed to appear in court for a second time and a bench warrant was issued, has he submitted himself to the jurisdiction of the court?
No, Your Honor. But a big question here is whether
we should ignore that and not apply the fugitive disentitlement doctrine?
Well, as the Court of Appeals has stated in Ventura, the doctrine should not apply when the absconding is involuntary. And here there are many factors.
That was involuntary deportation, and I don't think that that's the issue here because the defendant's whereabouts are unknown.
Well, Your Honor, with all due respect, it's going to be up to the lower court to make any fact-finding on that. And so here we have...
I'm referring to Ventura.
Yes.
Would you agree with me that in that case, there was deportation? That's
Yes.
a yes or no?
Yes, Your Honor.
Okay, so in this case here, do we know where the defendant is?
No, Your Honor.
All right, so it's fair to say that, well, let me ask you this question. Do we have any indication that he's been deported?
No, Your Honor.
Thank you.
But I would state that the equivalent of voluntariness for deportation would be similar to perhaps health issues. The problem here is that my client in his last appearance had COVID. He's a homeless man. He has like severe physical issues that can cause severe problems with that.
So are you saying that he's deceased?
I
Or
don't know.
are you saying he's
That's the problem.
hospitalized?
My office have been trying to find out if he is.
And have
but
you
we-
checked,
And we,
if you would just let me ask the
I'm
question.
sorry.
Have you checked the hospitals? That's,
Yes, we've done searches as
it's been
far
a
as we
while.
can. Yes,
since he absconded, since he didn't report, it's been a while.
yes.
Okay,
But-
so
well-
have you checked the hospitals during that time to make
we've-
that
yes.
determination?
Yes, but in terms of voluntariness, like, I believe it's not up to this court to be able to know if he was voluntarily absconding or not. And I think that's the point of what Ventura is. Like, the doctrine is about someone who purposely has absconded to avoid the court's jurisdiction. And if he's ill, and we're talking about someone with severe mental illnesses, someone who's suicidal, who's...
So your question is with regard to the substantive aspect, it's with regard to acceptance of responsibility. Why didn't the court properly address that when the defendant, was very careful about the way he described the positioning of his hand on the woman's buttocks in order to avoid having to say that he touched her groin area?
Well, I think
Why
that,
isn't the judge's assessment of that as not acceptance of responsibility a valid one?
you accept responsibility for the offense that you pleaded guilty to. The offense that you pleaded guilty to was persistent sexual abuse, which is sufficiently alleged when you touch someone's buttocks. So for the court to say you also had to admit other allegations that are irrelevant to what he pleaded guilty to, it's insufficient and also a due process violation. He was never, the prosecution never even required him to admit to touching any other body part. And for
Well,
them
he
to now-
he already admitted to touching any other body part. I think he said that his hand went down, and I'll let you answer the question. I'll ask it again in rebuttal.
Okay.
Thank you.
Good afternoon, and may it please the court, Faith DeTrolio for the people.
Counsel, why shouldn't we address the merits of counsel's argument that, with regard to acceptance of responsibility?
To the fact that defendant is absconded, or?
No, acceptance of responsibility.
Yes, so on appeal, defendant is not disputing 100 of the 110 points that he received. The remaining 10 points were, as the court noted, for factor 12 for his non-acceptance of responsibility. Despite being given multiple opportunities to do so, defendant repeatedly failed to genuinely accept responsibility. In front of the SOAR court, defendant testified, and the SOAR court found that he was cagey, that he was clearly minimizing his actions in the way that he was moving his hands.
Well, counsel says that what he said was sufficient to be given points for acceptance of responsibility.
Well, Your Honor, in the plea allocution, defendant pled guilty under like a general definition of the offense. That encompassed all of the actions that were alleged in the felony complaint and by the victim in her grand jury testimony and her demonstration to the grand jury of how the defendant touched her. So defendant can't argue that he did not plead to those actions. Additionally, as I was saying about the SOAR hearing, defendant clearly refused to expand upon how his actions, the full extent of his actions and how he was touching the victim.
He
Alternatively,
actually did a demonstration in the court as to what he did. Am I right?
yes, you are correct. And the SOAR court found that the way that he was moving his hands was a clear minimization of his actions. He was not genuinely accepting responsibility to the full extent of his actions.
Isn't that the key word, that the acceptance of responsibility has to be quote-unquote genuine?
Right, exactly. And despite multiple opportunities to do so, he failed to genuinely accept responsibility. He only minimized his actions in this case. In the pre-sentence report and at sentencing, he was telling the Department of Probation and the court, respectively, that he only touched her buttocks and he refused to discuss the full extent of his conduct. And additionally, defendant is not entitled to a downward departure. There are a lot of aggravating factors that weigh against his request, such as his extensive criminal history and the sexual misconduct that he committed while incarcerated.
So even if we give him the 3 points or the 2 points for whatever the number of points are, does he go below a level 3?
I believe that the 10 points were taken away for factor 12. He would be a level 2, but as he was already a level 2 going into this this adjudication, and so it's clear that that did not deter him in the past.
Counsel, would you address your adversary's argument that the mere plea of guilty is sufficient to satisfy the standard?
Well, Your Honor, defendant did plead guilty in this case, but
Why isn't that enough?
he later did not accept responsibility. So yes, he pled guilty, and his plea did encompass all of the factors and all of the elements that the victim talked about in the grand jury, and that is alleged in the felony complaint. But then he went on to later contradict those statements and, contradict those allegations and say that he did not commit the full extent of those actions. This court has held many times that contradictory statements and statements such as a plea and then statements not accepting responsibility entitle the SOAR court to assess 10 points under factor 12 for non-acceptance of responsibility. It should also be noted, as the court noted, that defendant is currently a fugitive, and so this case should be dismissed with prejudice. If there are no further questions, we ask that you affirm.
Thank you.
Your Honor, just to answer your question from where I left off, I believe...
Just that where we were at the end of counsel's argument, I think, is where I left off as well, is this idea of acceptance of responsibility when you plead guilty versus having to say more than what you've said in the allocution for the plea of guilty.
Well, so there's no question that his statement saying he's touched her buttocks, that was enough to make up the charge. If the prosecution wanted a factual allocation to anything else above that, they should have required that as part of the plea allocution. So for them to now allege, hey, you had to accept responsibility for all this other stuff that was irrelevant to his plea of guilty, it's improper here, and improper for the court to also require that. I believe, why did the court require that? They either improperly required someone to admit to every single allegation made against them, which is not what a plea of guilty is to.
Well, there's a difference, sir, right, between the allocution that's necessary to satisfy a knowing, voluntary, and intelligent plea on the one hand, and what needs to be said to manifest a genuine acceptance of responsibility for the purposes of allocating 10 points under factor 12 of SORA.
Yeah, well, and he allocated what his allocution was about was to touching buttocks. Like, as I mentioned, if they wanted him to accept responsibility for anything else, they should have made that as part of the plea. So he accepted responsibility for what he pleaded to. And it's also very important to note that it's not the defendant's burden to prove his acceptance of responsibility. It's the prosecution's burden to prove by clear and convincing evidence that he did not accept responsibility. And here, every single case that they've cited in their brief included an affirmative statement that I did not do this, that it was the victim's fault who did it. And so they didn't prove their burden here. And just one last point, if I may, if this court was to apply the fugitive disentitlement doctrine, I would ask that it do so and dismiss without prejudice to refiling the case if and when my client is found. Thank you.
Thank you. Thank you both. Rome Capital versus Asia Alternatives Management.
Good afternoon, Your Honors, and may it please the Court. Gabriel Herman with Gibson, Dunn & Crutcher, LLP, for Appellant Rome Capital, Inc. Your Honors, the trial court acknowledged here, or at least purported to acknowledge, that the contract at issue is governed by substantive principles of Colombian law, but it utterly failed to apply those principles in construing the agreement and Rome's other claims. Rather, it impermissibly allowed principles of New York law to infect its analysis, and ironically disregarded well-settled principles of New York procedure in ruling that this case should be dismissed on the pleadings.
So if New York law and Columbia law are the same, then New York law would apply, and that's what the lower court found, that there was no difference between them. Your position is that there is a difference between Columbia law and New York law with regard to the right of first refusal or the preferential pact. Is that right?
There is a difference, Your Honor, and I don't believe the trial court held that there wasn't a difference. What the trial court said was the words in English necessarily provide only a limited right, as the trial court interpreted it, that is purely the right to preempt a third party.
Well, with regard to your experts' positions, isn't there a difference between the right of first refusal and what's called the preferential pact here? In their
What our
their
expert
explanation?
testified is that Colombian law requires analysis of all evidence of the party's intent, including what's reflected in the writing, but not limited to what's reflected in the writing, and that if there is evidence of a will contrary to what might be suggested by the writing, that will must trump what's in the writing. And our expert also testified that Colombian law recognizes no special meaning for the phrase right of first refusal, as opposed to New York law, which in fact recognizes that term as a term of art, a legal meaning that is preferred over the ordinary meaning of the words.
And so doesn't your expert talk about a preferential pact?
Our expert did discuss a preference pact. That was really to address an argument Asia Alternatives previously made but has since moved on from about suggesting that this was akin to a preference pact. Originally, Asia Alternatives expert suggested that preference pact was the equivalent of a right of first refusal in Colombian law. It's not, and our expert explained that if one did construe these words to be the equivalent of a preference pact, we would win. It would provide the right that we maintain Rome was granted. But what our expert really said is you need to review the words on their face for their plain meaning and the other evidence of the party's intent. And here, the record, which was our pleading, to which we annexed dozens of exhibits of actual evidentiary material, we went far beyond what a plaintiff is obliged to do in a pleading, the record was undeniably clear, or at a minimum sufficient to support an inference that in fact the parties intended to grant Rome the right, the exclusive right, to be the first party to decide whether or not to provide the services at issue, including before AA itself providing those services. So for example, prior to execution of the contract, the parties, and the important thing to keep in mind here is the purpose of this agreement was the parties knew it would take a multi-fund cycle in order for this business relationship to get off the ground. The Latin American market was unfamiliar with investing in these Asian
Yes, the idea was
funds.
for them to get the business, get people who are willing to invest in the Latin American market.
Correct.
For number 5, or whatever that Roman numeral 5.
And Rome knew that at the first cycle out, only some of its investors would buy in, but the second time around and the third time around, it would grow exponentially.
And that's why they proposed this ROFR.
Correctly,
so
to
that
have
they
the
could-
protection that after opening its Rolodex and sharing all of its confidential business intelligence about this market and these investors, that it wouldn't be circumvented by AA, who just cut it out of the picture, which is exactly what happened. So the parties knew that this was the purpose, was to protect Rome from circumvention. Before entering into the agreement, AA said they were looking to, quote, outsource fundraising for Latin America to Rome and to, quote, have a multi-fund 10-year relationship. Its managing partner told Rome's CEO, quote, we look forward to working with you for years to come. And they agreed to give Rome, quote, a right of first refusal for exclusivity on LATAM placements, not a right to be our agent if we decide we want an agent, a right of exclusivity on LATAM placements. Later, after they executed the agreement, they continued to acknowledge as much. quote, "We have given you the right to raise Fund 6 exclusively in LATAM because, quote, that is where we see and want all the value and new money to come from." They claimed, there is no way we would poach or undermine these relationships from you. They said they entered into the relationship with the, quote, "understanding that, quote, you would be a permanent extension of Asia Alternatives in LATAM, and we would work as partners for years and years to come." It told Rome, quote, "Once Fund 5 is closed, we do not require you to spend any time on Asia Alternatives until you decide to represent Fund 6. They told Rome, quote, "You continue to have full ROFR to raise Fund 6 for LATAM."
So it's your position that when Rome said, we're going to raise the funds for Fund 6, there didn't have to be an offer to a third party from Asia. It was
Correct.
automatic based on
Correct.
your interpretation.
All that needed to happen, which did happen, is that AA needed to decide that it wished to raise investments from Latin America for Fund 6. It did that. That was the only condition necessary to ripen Rome's rights. And so when Rome exercises right, it is binding. And AA can't later turn around and say, actually, we're entitled to do it, to go it alone. All you have is a right to preclude another third-party agent. That's not what the agreement says. It's not what the evidence shows the parties intended. And it's not what Colombian law permits any court to conclude on this record. So, Your Honors, respectfully, the trial court was led astray and improperly allowed New York principles to infect its analysis. I see my time is up.
Thank you.
Good afternoon, Your Honors. May it please the Court. My name is Blaine Green on behalf of the respondent, Asia Alternatives. This is fundamentally a contract dispute. The trial court properly dismissed the claims based on the plain language of the contract. The right of first refusal is it's actually...
I guess the million-dollar question is, whose plain language? New York's or Colombia's?
Right.
Right of first refusal.
And there is no, as counsel has conceded, and as experts for Rome conceded, there is no right of first refusal concept or term of art in Colombian law. There is, obviously, a plain meaning at common law in general and under New York law and just the definition of right of first refusal. So it doesn't exist under Colombian law, and that's why it's proper for the court to simply analyze the ordinary plain language of right of first refusal. The agreement in Section 7H could have said, at Rome's election, or if Rome chose, or that Rome had an option, or that Rome had a right, a simple right, not a right of first refusal. It doesn't say any of those things. So this was a plain language application by the court. Now, the trial court didn't actually rely on New York law specifically, or on New York cases specifically. It relied on the plain language, which is what counsel says the court should have done. This was an application of that language. Now, counsel has made the argument, well, there was evidence of contrary intent, and my client thought something different. But there are several responses to this. First, under Colombian law emphasizes the prevalence of the will and the primacy of the contract. The contract itself is the primary source of the party's intent. This is even more true where there is a merger and integration clause, which this contract contains. And Colombian law is clear that such clauses, which they call clauses of integrity, are enforced under Colombian law.
That sounds like familiar New York law.
It is like familiar New York law with respect to merger clauses being enforced. And then the last point of Colombian law is that evidence, extrinsic evidence, for it to be relevant to interpretation of the contract, there has to be clear evidence of contrary intent. There is not clear evidence of contrary intent here. Counsel has described that there was correspondence where Asia Alternatives said it wanted to have a long-term relationship with Rowam, where it said Rowam was entitled to exclusivity, where it said Rowam still had a ROFR and a right of first refusal. Those things are all consistent with, yes, Asia Alternatives wanting to continue working with this placement agent long-term, but they don't require Asia Alternatives to hire it again for Fund 6. Rather, they simply require Asia Alternatives to grant exclusivity so that it doesn't use some other placement agent before first offering that opportunity to Rowam.
Can you repeat that, what you just said? I'm sorry, I didn't hear the first part of it. You said it doesn't,
It doesn't require Asia Alternatives to hire Rowam as the placement agent for Fund 6 if Asia Alternatives decides not to use placement agent at all for Fund 6.
but isn't that one of the things that, I know you say there's no, I think you said there's no difference, that your expert, says that a right of first refusal is not recognized in Colombian law, and therefore we just have to take it at its plain meaning. But it seems like the two experts, at least the plaintiff's experts, seem to include that you don't have to go to a third person to offer it to a third person for the plaintiff under these circumstances to be able to accept the option. It's as if it's built into the option. I mean, it sounds like it's very different. I mean, the purpose of having these experts was to get their opinions, and it sounds like the plaintiff's expert is saying something that's different than the defendant's expert, or at least elaborating further. So if they both agree, it seems like the plaintiff's expert elaborates and explains that you don't have to go to a third party to present this option, that the Colombian company can just say, I'm going to raise the money for your Fund 6, and because it's built in, because that option is built right in.
So on Colombian law, and this was the purpose of the experts, was to help the court determine what is Colombian law.
Right.
And the experts agree there is no such thing as a right of first refusal under Colombian law. They also agree that extrinsic evidence of intent is only relevant where it is clear and contrary to the plain words of the agreement. And then we have an argument, essentially between counsel and the briefs, about whether there is such clear evidence of contrary intent. Now,
Isn't the right juncture to weigh that evidence at summary judgment as opposed to 3211?
not where there is an integration clause and the parties have agreed that the full intent of the parties is expressed in the contract. And then lastly, I do want to address this circumvention issue because Rowam essentially argues, well, Asia Alternatives can't provide these services for itself. And this is really a critical, I think, fundamental mischaracterization of the ROFR, the plain language of the ROFR, and what Asia Alternatives does as distinct from Rowam. So I'm going to read Section 7H. The client hereby grants Rowam a right of first refusal to provide on an exclusive basis the services described in Section 1 of this agreement in connection with the next fund. Now, what are the services described in Section 1? Those services are clearly placement agent services. Section 1A is, quote, familiarize itself to the extent possible with the business and operations of the client. Identify and screen prospective investors. Assist the client in its promotional efforts. Provide such other services with respect to the private placement as shall be mutually agreed by the client and Rowam. These are only services that an agent can provide to the principal. So Asia Alternatives couldn't just go out and hire a different agent without first giving that opportunity to Rowam. But it wasn't required.
I'm glad you brought that up. I'm glad you brought that up because now, help me here. Now, Asia, right? Asia Alternatives, now, they could identify and screen prospective investors, correct?
Yes?
Okay. And also contact them to set up introductory meetings, correct?
Yes?
All right. And now, Rome did allege that you admitted that you had raised investments for Fund 6 from Latin America, correct?
I'm sorry, from?
For Fund 6, from Latin America, right?
Yes.
Okay.
From pre-existing investors
Right.
on Fund 5.
This was the allegation. So since you already indicated that Asia alternatives could identify, screen, et cetera, that means, as alleged, because we're only focused on the pleadings, that you also identified, screened, and contacted investors without the need for a third party. No?
But
No, I mean, that's a yes or no, right?
So no, if you look at the Section 1 services, there are clearly services that a placement agent only can provide. It clearly contemplates familiarizing itself with Asia Alternatives. That's us. So Asia Alternatives doesn't need to familiarize itself with itself. So this right of first refusal, the nature of a right of first refusal, doesn't prevent the grantor of that right from actually doing the own thing. It's not engaging in services. Asia Alternatives wasn't engaging in services. And while Asia Alternatives did raise money from pre-existing investors on Fund 5, Rome was paid on those investors. That was the whole point of the tail fee, was so that even if Rome was not acting as placement agent on Fund 6, it would still be paid a percentage fee on those investors who re-upped from Fund 5 into Fund 6 directly from Asia Alternatives without using a placement agent.
Any further questions? Thank you.
Thank you, Your Honors.
Thank you, Your Honors. Just briefly, I think Your Honor's question is exactly on point. Mr. Green and I must be reading a different contract. It boggles my mind how he can say that AA wasn't capable of performing any of these services itself. It is alleged and effectively admitted that, in fact, they did perform the services. I don't know what he's reading from, to be perfectly honest. Just a few points in rebuttal. Counsel suggested that the court applied a plain language application. Neither the court nor AA has identified how these words compel the limitation that this is purely a third-party right. It doesn't flow from the words. It flows from the legal meaning that New York law has ascribed to them, and perhaps other common law jurisdictions. But guess what, Your Honor? Columbia is a civil law jurisdiction, not a common law jurisdiction. It does not adopt those legal meanings, and it was error to apply them here, whether the court acknowledged that it was in fact what it was doing or not. The plain language supports Rome's position. The plain language of this provision contains no reference to third party, other agent. He read you the clause. Those words aren't in there. He also mentioned, well, the agreement could have said such, that, and the other. It's very interesting because, in fact, after this dispute arose, AA attempted to adopt an amendment when they, for the first time, revealed the position that this was supposedly just a right to preempt a third party. They proposed an amendment.
That was unusual, the retroactive, asking them to sign the agreement from backdated.
A retroactive proposed amendment that would have added language to say that Rome's right arises only if the client decides to engage a placement agent for a private placement in Latin America for its next.
If it was already in there, they wouldn't have needed to prepare that document.
Precisely, Your Honor. And on a motion to dismiss phase, I would submit, Your Honor, the implication of that is clear. The only reason they sought to insert that was because it wasn't in the agreement to begin with. But at a minimum, we were entitled to that inference, and the court below completely dismissed it and just read this clause as somehow consistent with her reading of the contract. That was error. Counsel also mentioned that supposedly Colombian law recognizes primacy of the contract. It does, but that's a principle what we would call freedom of contract. Colombian law recognizes private parties are free to make contracts that are not unlawful and contrary to public policy. It's not a principle of contract interpretation. The principle, the guiding, the number one principle of contract interpretation under Colombian law is prevalence of the will. Their expert attempted to turn primacy of the contract into an interpretive principle. Our experts explained, using his own sources, why that was in fact false, and he brought in no rebuttal. There was no response from AA's expert to our expert submission showing, using his own sources, that in fact, the will of the parties must trump the text of an agreement, even if the agreement is clear.
Sir, if I understood your friend correctly, though, that in his view, a merger clause would prohibit or bar any extrinsic evidence or parole evidence of the will of the parties.
So, Your Honor, Colombian law, which again is a civil jurisdiction, is code-based. There is no code provision that recognizes the concept of a merger clause in Colombian law. Our experts explained that as well. Again, no rebuttal from AA's expert. At best, when these sorts of clauses are included in contracts governed by Colombian law, they are evidence of the party's intent to be weighed in the mix with everything else. And if you read the clause here, what it says is the agreement integrates the entire understanding of the parties and extinguishes prior agreements. Okay, the purpose of that typically is to wipe the slate clean when you write a contract after having had a previous agreement. That's not what's at issue here. We're talking about evidence of the intent the parties had with respect to this agreement. And in any event, most of the evidence we've cited from outside of the contract comes after it was executed, during the performance phase. So even if you credit the merger clause in the way a New York court might, it only excludes evidence of what came before, not evidence from the course of performance, which clearly shows the clause meant what Rome says it meant. Your Honors, the decision below should be reversed.
Thank you.
Thank
Thank
you.
you both. Piana Forte versus Nisha.
Good afternoon. Thomas Fogarty from Kiernan Trebach for the Appellate Cordon Construction Corp. In this case, plaintiff claims to have been injured on February 28, 2017, when he stepped in a core hole while walking backwards at a construction site. A core hole is a hole in a wall, or in this case, the floor, used to
Counsel,
run
could
things.
you, since we're familiar with the facts,
Oh, sure.
would you kindly compare the testimony of Mr. I don't know how you say his name, Corlisi or Corlos, the construction superintendent for Cordon, who said that his company did not require use or drill any core holes for a period of more than a year, including the period when the incident occurred, as opposed to Mr. Agathopoulos' testimony, Technico's project superintendent, who said that he wasn't sure if Cordon had used core holes. He didn't remember if they had, where they were. How, using the testimony of those two people, how are you entitled to summary judgment here?
Sure. As you stated, the Cordon witness, I'll avoid his name, testified that the Cordon did not drill any core holes while he worked on a project, which was from late 2016, early 2017, through June of 2017, which covers when the plaintiff's incident occurred. The technical supervisor testified.
I'm gonna, if I can ask you, Mr. Agathopoulos is, I think he's your best witness, right? Perhaps I'm wrong, but he says that he can't recall where any of the holes were drilled. But then at his deposition, he's shown a picture of the very place where the plaintiff says he fell, and he says, oh no, those are pre-existing holes because that cement looks old. So how then can Cordon establish that anything about when the holes happened or who did the holes?
No, Your Honor is exactly right. The one witness that the lower court hung its decision not to dismiss against Cordon on said that the hole that the plaintiff tripped in, to him...
It's not your best witness, that's not what I meant, but he's...
Right, he believes that the hole pre-existed the construction project and that it was not even used for HVAC purposes, but for electrical conduit.
So aren't you stuck?
No, this is
No, I don't...
Oh, I'm sorry. I got it wrong. I got it backwards. So this helps you, of course.
Right, no, correct. There's no affirmative evidence of that Cordon drilled or even used the subject core hole.
Except that Agathocleos does say, I'm sorry, I probably pronounced his name wrong
Right.
again, but
I've
he
been calling
says
him
that
Spiro.
everybody made holes. I mean, that's what he said
and
before
no, and
looked at the
he
photos.
testified that
Everybody made holes.
that Cordon may have drilled core holes, but there's no time frame. The one time frame we have is when the Cordon witness was on the site, which spanned the plaintiff's incident, and he says definitively that Cordon did not drill any core holes during that period. And in fact, the technical witness stated that he couldn't even think of any reasons that any contractor at all would have to drill a core hole in the area where the plaintiff's incident occurred.
Anything further?
Nope.
Thank you, thank you.
Good afternoon, Your Honors. May it please the Court, Dana Catanzaro on behalf of Respondents, New York City Housing Authority and Technical Construction Services.
I'm going to just ask you the question that I asked him, and it is, I mean, it's your best witness, I think, Agathocleos, who says, I think he names 3 different companies that would have been responsible for making holes. So maybe a question of fact there. But then he is shown a photograph and he identifies the specific holes that the plaintiff fell in and said, well, no, those must have been pre-existing because the cement is old. So what do we do with that?
Your Honor, I think as the lower court correctly found, there's so much conflicting testimony, not only between the different parties, but between my witness, Spiro, whose last name I cannot personally pronounce correctly either, but his own testimony contradicts itself multiple times. He doesn't know. You
mean Mr. A, we'll call him Mr. A.
Mr. A's testimony. So,
okay, but what do we do with the last thing he says? I mean, he may say that everybody did holes, but then when he's specifically shown the very holes, he definitively says, no, those are pre-existing because the concrete is old. So he identifies the holes and he identifies the reason why it's not those holes.
Yes, Your Honor, and then at another point in his testimony, he admits that he's not actually certain, that he can't be 100% positive.
I just want to go back. Well, you know what? I want to stay there because Mr. A testifies repeatedly that the holes are pre-existing and talks about other holes that Cordon, opened, but that was for the sprinkler system, which was not the accident area. And in addition, the numerous times that he said that the holes were pre-existing, he also indicated that the floor was not recently poured. So how does that affect your position?
There was, Your Honor, I think it's important to note that there was also testimony that Cordon used core holes potentially for their use of vacuum pumps. And as the court noted in its decision, one of the undisputed facts, and this is in the record on page 17, was that Canta, who is another contractor at the site and the plaintiff's employer, placed Cordon's people on the site in the month of the accident specifically. Cordon's own witness did not recall if they were on site in February. Having read the depositions multiple times, having read the briefs multiple times, it's very clear that what we have here is a triable issue of fact.
So I just, again, with regard to the question that I asked, with regard to the identification of the holes that Mr. A was shown the photograph and then said that the cement was pre-existing, What do you have to contradict that testimony? You said there were places in the transcript where he said the opposite, or he said that he wasn't sure, specifically with regard to the concrete being old and the holes being pre-existing. What page of the deposition is that?
I'll need to check that, Your Honor, for the exact page. However, regardless,
Well, that's
whether
an
the
important
holes-
fact. I don't know that I can say regardless, because if he doesn't contradict that, that seems to be everything. We're not talking about holes made by 3 different companies in various places. We're only talking about the holes that plaintiff alleges that he fell through or caused him to fall.
And the testimony is that, so notwithstanding the fact that the core holes may have been pre-existing, they could not affirmatively say whether or not Corden used the pre-existing holes to install the vacuum pumps, or they used the holes that they did drill on the site.
So you mean they should have been responsible for covering them if they used them?
And that is also the testimony of multiple of the parties here, especially Technico as the general contractor, that if a subcontractor used a core hole or moved the cover of a core hole, it was their responsibility to replace that cover on the core hole.
And what did they use the holes for? That
They were used by multiple trades for multiple reasons. It could have been used for the vacuum pumps, it could have been used for the sprinkler system, Vital Plumbing, Canta, Corden. These were all subcontractors on the site that used the holes for different reasons. And that was precisely why the lower court noted that with all of these different uses of core holes, with all of these other contractors there, with Corden not even being able to identify when they were on site last, and Canta's testimony placing Corden on site in the very month of plaintiff's accident, it was impossible to determine who caused the condition that created plaintiff's accident, which was the uncovered core hole.
So you're saying it's not just the making of the holes, but it was the use of the holes and identifying who may have used that hole.
Exactly, Your Honor. And from the testimony that has been had in this case in its entirety, it's impossible to definitively say who caused that dangerous condition. And for that reason, the lower court correctly denied summary judgment to all parties on the issue of causing the defect that led to plaintiff's accident.
Now, counsel, wasn't Technico responsible for closing off and covering the holes?
Yes, Your Honor, if Technico was given notice by one of the subcontractors that there was an open core hole, it would have been their responsibility to cover it. However, the record indicates that there was no notice about this open core hole until the accident happened.
Now, I want to go to Corden's testimony, because I thought there was testimony that indicated that the work that was performed didn't require it to drill or to make any holes in the area where plaintiff had the accident. And so my question to you is, going back to Mr. A, was there any testimony that he provided that contradicted this testimony? Because I don't recall seeing that.
His testimony, Technico's testimony, was that he was not sure where Corden drilled the core holes. And that was in the record between pages 769 to 70, 775 to 76, and 769 to 711.
So I want you to focus on the use of the holes and, versus the making of the holes, because you're talking about 2 separate issues, and you're talking about notice to cover the holes. So where did anybody testify about the use of those holes for plumbing or sewage or sprinkler systems or anything else, the use of those holes?
Again, the photos of the core hole that plaintiff identified as where his accident occurred was not the Mr. A of my client Technico did not know for sure, because he was not there when the accident happened. He was only going off the photographs. And the fact is, we don't know who used that core hole in the month of the accident. We know that Corden was there in the month of the accident. We know that they used core holes, and we know that there were multiple uses for those particular core holes.
Okay, thank you.
Thank you, Your Honor.
Just a couple points in rebuttal. Mr. A testified that Corden's work in the room did not involve the use of core holes, and he could not think of any reason that they would need to use the subject core holes. That's on pages 769 and 771 of the record.
But there were, I think there's, I don't know, it's Technico, there's Corda, there are 3 different companies that Mr. A talks about making the holes, but so presumably, Corden, Canta, and Vital. So presumably these various contractors, maybe they didn't make the holes, but they used the holes. Is there anything to contradict that fact?
That's throughout the project, not in the subject's room.
Well, right, I'm asking you, is there anything that definitively indicates that, in other words, Mr. A seems to definitively state that those holes weren't made by anybody because the cement is old. But was there some testimony by someone that also indicates those holes weren't used by anybody?
Yes,
or any of those things?
Yes, on pages 769 to 771. And I just wanted to clear up, he did testify that if a subcontractor...
And who makes the statements in 769 to 771?
Mr. A.
Mr. A?
Yeah.
About Cordum?
Yes.
But Cordum was just one company. There was also Canta and Vital. And Mr. A says that holes were drilled in the process of installation of the new boiler by various contractors. My question is, were the holes used by various were those holes, even though they weren't made, were they used by various contractors?
Right, an ancillary issue and why Corden got named in the first place is the plaintiff repeatedly refers to the room that he was injured in as the boiler room. The boiler room's actually on the other side of the building. He was injured in a mechanical room. So any references to the boiler has nothing to do with this incident. And just one more thing.
Well, they may have used the wrong name, but are they talking about the specific room?
Well, if the testimony is regarding a boiler, the installation of a boiler requiring core holes, then yes, it's not applicable here. There was no boiler in the room where he was injured.
I don't know that that's clear from what Mr. A says, but in any case, why don't you, did you have something else to say?
Yeah, the last thing was Mr. A did testify that if a sub created a core hole, it would be their responsibility to cover it, but there was no testimony as to if a sub used a core hole that they had any responsibility to cover it.
So if they used a hole, you're telling me they could leave it open?
There was no testimony either way. I mean, again, it's inapplicable.
It doesn't sound like something that makes sense. If there's a hole and you use the hole, maybe you should cover it.
Agreed, but you know construction sites, the union guys, if it's one guy's job to cover the hole and somebody else does it and steps on his toes, it's a problem, so.
Okay, thank you.
All right, thank you.
Both. Nunez de Rivera versus 3051 Fulton.
Good afternoon, Your Honors. May it please the Court, my name is Paul Josephs. I'm an attorney from the law firm of Hannum, Faratek, Prendergast, and Merlino, and we represent the appellant 3051 Fulton LLC. On re-argument, the Court did not consider the evidence which demonstrated that the co-defendant witness, Xiao Dan Hu, the owner of the convenience store where in front of this, where the accident was located, she admitted that she failed to lock the cellar sidewalk doors.
Did she admit that she failed to lock the doors, or did she say that the doors, that if the doors were unlocked, they would not be level?
That's correct, Your Honor.
Right, that's a big difference
misspoke.
than saying, I definitely left those doors unlocked. I think what she says was, if the doors are not locked from the inside, then they're going to be misleveled on the outside.
That's correct.
You have to lock the doors, pull the doors down, and then you have to put a bar in, and the bar maintains the level position and keeps them from sort of swaying and
sagging. Yes.
Sagging, thank you, that's the word.
And she testified at length at her deposition regarding the necessity of whenever there was a delivery that it was required that someone from the convenience store, because she testified that they were the only ones who had keys and access to this particular cellar vault door. Someone had to unlock it from the inside, take the bar across, and then go outside and unlock the padlock. The plaintiff alleges that the door, and Ms. Hu stated that they are only misleveled when someone fails to properly secure them from the inside.
So you're suggesting that the only people who could have left it open was Ms. Su.
Ms. Hu or
Ms. Hu.
her husband or one of her employees, but I'm sorry to cut the cord off.
No, it's quite all right. You're asking a question, just making a statement. But what about the fact that they say that they had keys, they were the only one who had keys, but also there was a question of whether the managing agent for the landlord had a key?
Well, there's no evidence to that effect, and the landlord, who Mark Koplowitz, who testified at his deposition, indicated that he did not have any keys.
He said he didn't have a key, but he didn't dispute or challenge whether or not someone else in his company had a key. So he left that open. I mean, if you have the opportunity to say, I don't have a key and no one else in my company has a key, but he didn't say that. I don't have a key. So there's somebody out there, and usually management agents have keys, right?
That's possible, Your Honor. However, the evidence clearly, though, demonstrates that Ms. Hu, she stated that the only way that this could have happened was if the doors were not, securely unlocked.
So let me jump in.
Sure.
Ms. Hu said that she and her husband had exclusive use of the basement area and the vault doors that allowed access to the basement area, right?
Correct.
And she also said that only she and her husband had the keys. To piggyback on my colleague's questions, is there any definitive testimony that anybody else had keys?
There is no testimony that somebody else had keys.
And the landlord disavowed having keys as well?
That's correct.
So where's the basis for the liability in your eyes?
The basis for liability is that we believe that common law liability should be asserted, attributed to the co-defendant who left the door open, the lock unaffixed, and allowed these doors they created the condition that was allegedly the cause of the plaintiff's accident.
Would you address the indemnification issue, please?
Okay, well, our client is the owner of the building, and they entered into a lease agreement with the co-defendant. And it is our position that as a co-defendant, they were responsible for maintaining the premises, and they occupied the cellar where they were storing goods and where the actual sidewalk vault was located. I believe I'm out of time.
Thank you. You can finish up on rebuttal.
Thank you.
Good afternoon, Your Honors. My name is Christopher Conway. I'm here for the respondent for Iconis and Fusco. May it please the court. Your Honor, I believe that the issue here is whether or not Judge Sanchez got it right on re-argument. And in the pantheon of judicial proceedings, re-argument is exceedingly rare. And more rare than that is to have a decision overturned after re-argument. And that's what we have here. We have a decision.
We're not really interested in what is usual or unusual. We're interested in the facts here and getting it right. So
we believe that Judge Sanchez got it right.
What is your basis for that?
Yeah, Your Honor, for a common law indemnification to be granted, it has to be demonstrated that the person who is seeking indemnification had absolutely no responsibility, and the person who is going to bear the responsibility caused the negligent action. We don't have that here.
What evidence do you have here?
Well, Your Honor, we just went over some of the testimony about who had access.
What of that testimony specifically are you relying on for your position?
Well, Your Honor, what we're relying on first is that there was no contractual indemnification provided, and that the common law, the reaching of the common law indemnification was based on a misapprehension of Ms. Hughes' testimony that after re-argument.
Tell me specifically what you believe Ms. Hughes' testimony stated.
We believe that Ms. Hughes' testimony was misunderstood or misapprehended by Judge Walker, who had retired, and then it was.
And the correct view of it should have been?
The correct view of it was that she did not create the condition, that there was no evidence that she created the condition. There's at best ambiguity as to who had keys.
So what evidence is there? Speculation? I mean, who else created the condition? She said she's the only one who has the key. She said, she didn't say that she left it open. Who else left it open?
Well, Your Honor,
we don't even know that anybody else has a key.
And that's the burden for the person seeking indemnification, to demonstrate that they had nothing to do with it.
He said he didn't have a key.
Well, Your Honor, we don't know if they didn't have a key or not.
He said he didn't have a key.
Well, Your Honor, I think the
landlord said, I don't have a key.
I believe that the landlord's testimony was ambiguous as to whether his agents had keys or not to the premises. I don't believe that it was definitively stated.
Was there anything said about an agent, or is that an argument that you're positing as a possibility?
We're saying that it's a possibility, Your Honor, because the possibility.
There's nothing backing it up other than your argument, right?
Well, Your Honor, the assumption that Ms. Hugh is the one that had left the gates unsecured is the assumption that the person seeking indemnification is trying to reach here, and we believe that Judge Sanchez got it right when she said no. There was no evidence.
It's not Judge Sanchez. You keep saying Judge Sanchez.
Yes.
Who's
Oh, I'm sorry.
Judge
I'm sorry. I may have gotten the judges wrong.
Ramirez?
Judge Walker was the original judge on the matter.
Judge Walker, okay.
Yeah.
It's Judge Ramirez.
Judge Ramirez, that's what I meant to say,
Ramirez,
Your
yes.
Honor. I'm
Okay,
sorry,
please.
but before Judge Sanchez a few days ago.
Thank you. Your time is limited, so let me just ask you a
Yes.
question. Where is it that the landlord says that there was a manager who had the key? Please tell me the line, the page in the transcript.
I don't believe that they said that they had a manager who had the key. I believe that the testimony is that they weren't sure if their managers or their agents had.
Tell me what page and what line that testimony is.
Your Honor, I'm going to rely on our briefs for that and the submissions for that.
So if I don't see it, it's not there?
Your Honor, I believe that the re-argument was well chewed over, and that, again, to overturn a previous decision.
Counsel, I'm only asking you to identify in the records specifically where it is. You're coming in here to argue. I am asking you, where in your transcript are you saying that the landlord said the manager had a key?
We don't
Would
believe
you
that the
please tell me
We don't
the
believe
page
that
and
the
line?
landlord said that the manager had a key. We believe it was ambiguous, and after re-argument, it was determined that there was no determination that Ms. Hugh was the causal agent for the negligent situation. And that's really the standard that we have here, is for indemnification. Is the person who is seeking indemnification, can they demonstrate that the person they're seeking indemnification from caused the unsafe and the negligent condition? And we don't believe that that has been demonstrated here. And we
So
don't
that
believe
if the landlord says, I don't have a key, and that's it on the record, then the only people who would have the key would be Ms. Hugh.
Well, Your
Is that
Honor, we
right?
believe that that's.
I'm just asking you, is that correct?
I'm not so sure if that's correct.
So if the landlord said, I don't have a key, and Ms. Hugh said, we're the only ones who have the key, we should
Well, I don't believe that's
speculate or assume that somebody else has a key?
I don't believe that's the landlord's testimony. I believe that they were unsure as to who else in their organization had access and a key for that. But we believe that really what we're talking about here is the lower court's decision to deny the indemnification on contractual grounds, which we believe was correct. And after re-argument, they denied the indemnification on common law grounds, which we believe that this court should uphold because it was a determination at a hearing where all the facts and evidence were available for the judge.
Well, thank you. We'll review the facts and the transcript and the testimony as well.
Thank you, Your Honor. May it please the court.
Just real quick, Your Honors. I'd like to just respectfully refer the court to specific parts of the record, in particular pages 291 through 292, where our client, Mr. Koplowitz, indicated, question, okay, you said you don't retain keys to the building at all. Who does, other than the tenants? Answer, I have no idea. Question, it's your building. Who have you given access to? Answer, I have given access to one person, the tenant. Now, who else the tenants gave keys to, I have no idea. You asked me a question, who has access to the building, and my answer is the tenants. What about yourself? Do you have keys to the building? Answer, I think I just answered the question. I said no. Further, on page 387 through 388 of the record, in May 2018,
I'm sorry, you said 287 to what?
387 through 388. And this is in reference to the deposition testimony of Ms. Hu. In May 2018, who had keys to the store? Answer, no one else has. Since the day I opened the store to now, my husband and I are the only two people who have keys to the store. We have not given the key to any of our workers.
Counsel, was there any testimony that the doors could be misleveled other than not being locked from the outside? We know what Ms. Hughes said.
Inside, I think you mean.
Inside, I'm sorry, inside, thank you. Any other cause?
No, there was no other testimony in the record, Your Honor.
Thank you.
If there are no further questions, I would respectfully request that the 2022 decision be reversed.
Thank you. Thank you both. Izaki versus Izaki.
Good afternoon, Your Honors.
Good afternoon.
To please the court, my name is Philip A. Greenberg. I'm the attorney for the plaintiff appellant, Dan Izaki. The lower court erroneously dismissed the case here with prejudice on a 3211 motion. As was established, although, again, I didn't draft the complaint, but what the complaint gets at is that the reason plaintiff is suing here is he is just trying to enforce Justice Katz's June 2019 order, which was unanimously affirmed by this appellate division in 2020, which held that the condominium apartments, which are the marital residence, were to be sold. The proceeds therefrom were to be equally divided between Mr. Izaki and Dr. Izaki. Dr. Izaki is his wife.
So we understand the facts.
Yes.
I think your dispute is with the fact that the wife purchased the loan and Mr. Izaki is still required to pay I think she purchased the loan for a discounted rate.
Yes.
And the Mr. Izaki is still expected to pay his half, take his half away out of the proceeds of his half of the sale of the house.
Exactly. That's exactly it, is that the defendant, Dr. Izaki, surreptitiously using a dummy company, purchased the DLL judgment at a substantial discount. And then when the apartments were sold, Mr. Izaki, rather than being charged his share 50% of what it cost to satisfy the judgment, was charged the face amount of the judgment. So that's why the June 2019, and that was how Dr. Izaki, the defendant, found to get around surreptitiously. Bear in mind, she didn't.
But this all sounds like it's part of the matrimonial action. Why isn't this application made to the matrimonial judge to reopen whatever it was or make a motion there?
Well, actually, Justice Michael Katz was the matrimonial judge. This action was brought.
But you didn't bring it with regard to the matrimonial action, right?
Well, my predecessor law firm brought it as to just enforce the June 2019 order. And again, I wasn't the attorney at the time. They then referred it back to Justice Katz since it was based on
Counsel,
Justice. Yes.
I'm going to refer to the transcript that's contained in the record at 28. The court said, whether you call it collateral estoppel or not, I think we can agree that all the allegations you're saying now was discussed on the record in front of me. Then I went ahead and issued my orders because I didn't think it impacted what I was being asked to do. I didn't need to make a determination what connection, if any, Ms. or Dr. Izaki had with Rockledge, because I didn't see how that would change anything I was being asked to do. So given that the colloquy, obviously, that took place, how does that impact your argument?
Right. So the colloquy in the three subsequent orders to this appellate division affirming the June 2019 order, the court never changed a 50-50 split. And as far as the colloquy goes, in part of that colloquy, the attorney for Dr. Izaki said, well, that's not really before us. What Justice Katz was referring to in those transcripts was that what was before him was not to modify the June 2019 order, and it never was modified, but to really put details in that Dr. Izaki moved to be allowed to buy out Mr. Izaki's 50%. In effect, instead of selling it to a third party, to pay him 50% of what was determined to be the market value. And so that colloquy, in no way, and as a matter of fact, the attorney for Dr. Izaki specifically said on the record that there was no connection between Rockledge and Dr. Izaki. But it was purely colloquy, and again, the orders that came out of there had to do with allowing Dr. Izaki to purchase, in effect, buy out Mr. Izaki, and a later order set the price that he was to be bought out. None of those subsequent orders and none of that colloquy said, oh, we're modifying, which, by the way, was the law of the case and affirmed, so he couldn't have done it anyway. But Justice Katz didn't say, oh, I'm going to overrule the appellate division that affirmed me and no longer make it a 50-50.
Assistant Presiding Justice Renwick, can I pose a question?
Why don't we ask it in rebuttal?
Okay, thank you.
Okay, thank you.
Good afternoon, Your Honors. Gerard Risso for Respondent Nina Izaki.
You know, I think I'm going to ask the question now. I think I can get the answer. So, counsel had indicated that this case is to enforce the June 2019 order. But did counsel even argue that below or set that as a cause of action in the underlying complaint?
No, Your Honor, it's not a cause of action in the underlying complaint. Counsel did not bring this as a motion before Justice Katz in the matrimonial, which clearly he should have. They filed a plenary action alleging fraud on the court, fraud, negligent misrepresentation. There was no claim to enforce the June 2019 order. They filed an RJI, which didn't even disclose the matrimonial as a related case. You would think a lawyer would do that if they were looking to enforce another judge's order that was rendered in a different case.
I just want to follow up. And so that June 2019 order, it was modified 3 times, right? And there was no appeal from either of those 3 subsequent orders.
Precisely. It was modified 3 times. There was no appeal. And it was modified to provide to Nina Izaki to do exactly what she did. After fully understanding all of the arguments that were set forth in the complaint about the allegations that she's hiring a so-called dummy company, and she's really getting the debt, she's purchasing at a discount, she's getting an unfair economic advantage. Justice Katz heard all of that in the matrimonial case. He issued 3 decisions. The last decision in August
It was raised in a reply at one point on a motion, so it kind of got smuggled in at the 11th hour of, it's not as though this was a fully litigated and actually determined issue whether a fraud on the court occurred.
Well, it was brought in the reply in March of 2021 in connection with the very first time that they brought it. In that cross motion, they specifically asked for the following relief: to make Nina Izaki disclose what the DLL judgment was purchased for, and to require that that judgment debt be retired for the amount she paid for that. Justice Katz affirmatively denied the cross motion. No appeal was ever filed from that. A couple months later, when Mr. Izaki wouldn't sign the deed to facilitate the transfer, we had to go back to court and seek contempt sanctions, and we asked Justice Katz to order that the disposition of the assets be pursuant to the closing statement, which is at 323 of the record. That closing statement says, pay DLL $1.9 million. Justice Katz did that knowing full well that they were claiming in that motion and two subsequent motions that it was unfair, that because they think or thought that Nina Izaki was getting an unfair advantage by paying the full amount of the DLL judgment. Justice Katz said, pay the full amount, then you whack up the proceeds 50-50 after that. Everything that was stated on that closing statement was done. That was not appealed from. None of, it was all, it all becomes
Just out of
final.
curiosity, is there a relationship between the defendant in this action and the entity that bought the debt?
My client has maintained throughout that she does not have any interest in the entity that bought the debt. And
Is there any acknowledgement or understanding that she benefited by, through the sale of the debt at a discount amount, or the payment of the debt at a discounted amount?
that issue was never determined factually, was never raised as a factual issue. Justice Katz said he assumed it to be true, but it didn't matter to his equitable distribution determinations, that he went ahead and made 3 subsequent orders following the June 2019 original order in the matrimonial.
Okay. Questions?
If there's nothing further.
Thank you.
Thank you.
Good afternoon, and may it please the court. Adam Silverstein of Otterberg, PC, for defendant, respondent, Rockledge Properties, LLC. 3 very quick points. 1, Rockledge was not and could not be a party to the equitable distribution order in a matrimonial proceeding involving Mr. Izaki and Dr. Izaki. So the attempt to recast the complaint now as a cause of action to enforce an equitable distribution order as to Rockledge doesn't work. 2, if the complaint was an action to enforce Judge Katz's equitable distribution order, then Rockledge doesn't belong in that case, and as to Rockledge, the action should be dismissed. And 3, if the complaint does assert the causes of action that it claims it asserts, then no cause of action lies against Rockledge. There is no cause of action independent for conspiracy in New York, and for the reasons that Mr. Riso mentioned, there was no underlying cause of action stated against Dr. Izaki.
I'd like, if I may, to ask you the same question that I asked your, I don't know if it's your adversary or your colleague. Is there any acknowledgement or understanding that Dr. Izaki had an interest in Rockledge?
Yeah, I can represent to the court, as I represented it to the lower court, that Dr. Izaki nor anyone, neither Dr. Izaki nor anyone in her family has any interest in Rockledge. And moreover, Rockledge did enter into a mortgage refinancing with Dr. Izaki as part of the closing of the real estate transaction.
Thank you.
So, Your Honor, since he said off the record about the refinancing, it has been since established that the company, that Rockledge is controlled and owned by Dr. Izaki's longtime live-in boyfriend who lives in the subject apartments.
Sir, ultimately, as I read your complaint in this action, it is just contained, it was full of allegations regarding chicanery that occurred before, alleged chicanery that occurred before the matrimonial judge, correct?
during the time of the matrimonial. Yes.
So, and I think one of your friends made this point, that wouldn't the remedy be then to make a motion maybe under CPLR 5015A3 to vacate any orders based on the purported fraud, make your record there, and then the judge assigned to the case would rule however he or she rules?
It would, except for one thing. The 3 orders that he talks about, the first one, none of them go to that issue. The first order was to allow Dr. Izaki to buy out Mr. Izaki's 50%. The second order was to set the amount for the buyout. And the third order was to hold Mr. Izaki in contempt if he didn't sell his 50% share to him. So none of those 3.
Well, if the orders had addressed it, you wouldn't have had to bring this action, right? So what I'm saying is you haven't teed up before the matrimonial judge, by way of a motion or an application, a fraud on the court type request for relief, because I guess, you know, the thrust of your argument is, by virtue of the buying of this at a discount, this debt, the contemplated equitable distribution was somehow corrupted or diluted, right?
Right. But
okay. And so to get satisfaction or relief under those circumstances, shouldn't that request go to the matrimonial judge?
It wasn't, well, the action that was brought, and it was interesting that Rockledge's attorney said they didn't belong in this case because it was a matrimonial, but earlier it was, you'll see in the respondent's brief, they fault my predecessor for not bringing the case in the matrimonial court, and that's why they didn't, because there was a second defendant involved. But again, it goes back to this. The 3 orders that they say we should have appealed had to do with who was going to buy it, what the price was, and then the third order enforcing the 2 prior orders. None of them went to the prior order affirmed by this court of the 50-50. And that's why we maintain, in addition to the others, which I see weren't addressed by the other side, that even if the motion to dismiss should have been granted, which we say it shouldn't have been, it should not have been with prejudice, and most certainly, and again, I realize my time is up, but as we show in our reply brief, even the cases that they cite show that Justice Katz, if he was going to treat it as a motion for summary judgment, which in effect he did, was required under CPLR 3211C to notify the parties in advance of the oral argument that he was going to do that, and it was never done.
Justice Kennedy, do you have your question?
I posed it to the other.
But do you want to pose it?
No, I'm good. Thank you.
Okay.
Justice Gonzalez.
In the complaint.
Sit down, please.
In the complaint at paragraph 5 at record 42, you say, with all this information and more, it is obvious that defendant Nina Izaki owns a beneficial interest in Rockledge and is lying about it in the divorce proceeding to obtain a substantial financial benefit. So my question is kind of a twist on what my colleague was asking, which is to say, how can we decide this issue on appeal if it hasn't been fully developed below?
Well, that's why we brought the appeal. Remember, it was a 3211 motion. If this court, as it should, reverses or at least affirms with leave to replead, then it will be fully threshed out in the court below, both factually and legally. And that's what we're asking for, is our day in court on that issue. Thank you.
Thank you.
Thank you.
Thank you all. People versus Sean Dyer.
Good afternoon. I'm Catherine Martone on behalf of Mr. Dyer. As set forth in point 1 of our brief, the evidence of the autopsy results in this case violated Mr. Dyer's right to confrontation.
Counsel, even if we find that the admission of that section of the autopsy report did violate the defendant's confrontation rights,
yes.
how could we find that that error was not harmless where he had a self-defense? I mean, he was saying, I am the guy, and all that document did was say, he is the guy, so.
Yes, so that really goes to the heart of the case, Your Honor. It is because the sole question in this case was whether Mr. Dyer's conduct was justified that this error was harmful. The only evidence in the case regarding the number of times that Mr. Dyer struck Mr. Shada is the autopsy results. So the issue is not whether Mr. Dyer inflicted the injuries or that blunt impact head injury caused death. It's the autopsy evidence that supplied the proof of the number of times. The number of blows, of course, goes to the heart of whether his conduct was in fact justified. And that this is the case, that this is in fact the case is—
I need to ask you a quick question. When you refer to the autopsy report, are you in fact referring to the laboratory report? Because I see those as two different documents. Are you speaking of them as one?
So we're referring to it's People's Exhibit 215. It's Dr. Maloney's report that includes her notes, the diagrams, and the photographic.
But the name is only, the name and the arrest number of the defendant are included only in the laboratory report, not in the autopsy report per se, prepared by Dr. Maloney. So I'm, is your focus not on the laboratory report, which does have the name and which has only references to, I'm going to call them the liquids generically that were found on the body?
Your Honor, I'm not quite sure I understand, because if what your question is directed to is whether Dr. Maloney's report, in fact—
It doesn't name him.
Okay, but—
It doesn't name him, it doesn't give the arrest number, it doesn't give any of those identifiers other than the generic information that you would expect to find in an autopsy report that was anonymous.
But I think what you're saying is the entire report, the OCME and the laboratory report, that's all part of it.
Yes.
And that does name him as the only suspect, and then it indicates his arrest number. Dr. Maloney's conclusions are not a part of the report. Those were redacted. But you're saying it's still indicated hit 10 times, splatters on the ceiling, but no conclusions as to what that meant. Is that what you're saying?
Yes, and what's key here is the descriptions of the head injury. And at pages 551 through 556 of the record, Dr. Hayes is testifying at length regarding enlargements of Dr. Maloney's notes describing the injuries, and he's basing his findings regarding the number of blows, which was a very large number. I mean, based on his testimony, the prosecutor was able to argue on summation that it was upwards of 15 blows, and that this went to the heart of the case is demonstrated by the jury's note, which during deliberations that spanned 2 days asked, at what point does a self-defense action need to stop before it is no longer considered self-defense? So the heart of our argument here is that the testimony regarding the number of blows that was based upon Dr. Maloney's report and findings, and the other portion of the transcript where Dr. Hayes testifies at length reading from Dr. Maloney's notes, is at page 594 and, 594, but also 596 of the transcript, and stating that what he believes her description of the injuries indicates to him about the number of times that, Mr. Shada had to be struck to cause the injury she described. So, Your Honor, my last point here is that the Court of Appeals has taken this issue, and People v. Ortega is pending. That case is fully briefed now. The last time I checked, which was a day or two ago, it hasn't been calendared yet, as far as I know, for oral argument, but it should be decided this spring.
But may I ask you, this case had a number of witnesses. It was like Rear Window.
Yeah.
So you had these witnesses who said, I heard him saying from the hour, everybody's consistent about the hour, you're killing me, you're killing me.
Yes.
And so, this is not just a question of the number of blows, it's about all of the other information here, and they hear even to the point where they can say it sounded like a hollow pipe making a ting-ing sound,
Yes.
independent of any number of blows.
Yes. So I would say,
Get him, also the dog, get him.
yes. So what the ear witnesses hear, though, is an extended struggle, which supports the defendant's argument that there was a confrontation. There was evidence that supported the defense contention that Mr. Shada was armed. What was Your Honor, I'm sorry, but I lost track of the other thing you said. Oh, the get him. Okay, so the defense argument was that Mr. Dyer was referring to the keys that were the subject of he was ordering Mr. Shada to get the keys that were the subject of this argument. This case.
Get him doesn't sound like get the keys.
Get him.
Get him doesn't sound like get them.
Get the keys or get the, but Your Honor, the point here is that there's no doubt that forensic proof is highly persuasive with a jury, and none of this other evidence established whether Mr. Dyer did in fact keep on going with his conduct, continue his conduct after a point at which it would no longer be justified. The fact that the jury deliberated over a period of 2 days and asked that question shows that this was key evidence. And at the least, Your Honor, given that it was so important and that the prosecutor stressed this, that Dr. Hayes was able to quantify the number of blows, that was at pages 1046 and 1049 through 50. She's emphasizing the fact that the evidence establishes the number of blows. You cannot say on this record that that wasn't important to the jury. This is a fundamental constitutional right.
One big difference here, though, Counselor, is that there were so many neighbors who recognized his voice.
Yes.
Because they were familiar with it.
Yes, they heard a struggle. There's no doubt that there was a fight.
And the defendant had minor injuries, whereas the victim had a bashed-in head, among other things.
Yes. So the question is whether the conduct continued after the point at which it was no longer justified. The prosecution chose to introduce this evidence to rely on this forensic proof. It certainly went to the heart of the case. At the least, the defendant was entitled to challenge the reliability of this evidence by cross-examining the doctor who made the findings.
Thank you.
Good afternoon, Your Honors. Franklin Gunther on behalf of the people.
Counsel, should we be holding this case because of People versus Ortega, which I think actually did the decision?
No, you shouldn't, Your Honor, because...
Why not?
Because regardless of what this court thinks of the Garlic decision cited in my adversary's brief, or even any new rule that comes out in light of Ortega, harmless error still applies in this case. And first of all, the rule that was applied below, and that is still good law, the redacted report was entirely admissible. if some new rule comes out in Ortega that alters that rule somehow, harmless error will still apply, and the admission would not have affected the verdict. And
What about the ACME report that says, identifies him as the lone suspect and has his arrest number in there?
so, Your Honor, I would direct this court's attention to the September 9th, 2014 hearing when, after defense counsel's motion was made on the report, this is before it was redacted, the judge basically said, you know, these are the things that cannot come in on the report. You can certainly examine the witness based on the objective findings, but any of the opinions and conclusions have to be redacted. The detective's report, the 61 is as it's referred to, has to come out. The ACME analyst, Mr. Leung, who identified the body, that was also heavily redacted. And then the court said, if there are further redactions, please let me know. And that is the extent to which the report was redacted. So there was opportunity to seek further redactions if defense
You're
counsel
saying it was
felt
unpreserved? Is that
to the extent that those just that document, Your Honor. And those things are not in dispute either. As Your Honor noted, the defendant was a suspect in this case. I don't think there was any dispute about that. He certainly didn't contest that he wasn't the person who committed this crime. There was no dispute as to even the cause of death. The only thing that the people's expert actually augmented, as counsel noted, was the number of blows. But the jury didn't need to see that to determine that, given the extensive injuries to the victim versus essentially the defendant walked away unscathed, didn't receive medical attention, was photographed in the immediate aftermath of the murder and had one bruise on his forearm and one bruise on his shoulder, there's simply no way that the jury could have concluded that this conduct was justified.
Are objective facts noted by the doctor during the autopsy, are those testimonial or non-testimonial?
Those are non-testimonial under Freycinet. And I would also note that, you know, nothing about what Dr. Maloney thought came out until cross-examination. The people were very deliberate in how they examined Dr. Hayes. They went through first the diagrams and then the photographs and asked him, you know, what does this photograph show? Essentially walking through all of the injuries to the defendant. And the only opinion testimony he gave was to the number of blows. And even if you, even if you accept a defendant's version of events, I don't think that there's any reasonable view of his own retelling of the murder that would have allowed the jury to conclude that his conduct was justified in any way.
But would his opinion about the number of blows be testimonial in any event, provided he didn't link it to the defendant?
Certainly, but he's on the stand and he can be cross-examined about that. On cross-examination, he was asked about what Dr. Maloney thought about that, but that didn't come out on direct. That was only defense counsel who brought that up. You know, Dr. Hayes' conclusions and opinions were subject to cross-examination, but that was all, to the extent that Dr. Maloney had any opinion about the number of blows or the cause of that was all redacted.
Are you suggesting that this was a defense strategy to create an issue?
I mean, I think the defense had their reasons for having the report redacted. There are certainly, under a Court of Appeals precedent, there were things that needed to be removed. We didn't object to that. We met with the defense counsel and we went through and redacted the report, which I have given to the court. And those things were, anything that was left was all objective information under Court of Appeals precedent, non-testimonial, and perfectly admissible. Unless there are other questions, we ask that you affirm. Thank you.
So, you know, this is the issue that the Court of Appeals is reconsidering, is whether the Dr. Maloney's findings regarding the injuries constitute testimonial statements. You know, the Supreme Court has held that a report prepared in aid of an active police investigation for later use at trial constitutes a testimonial statement. There's no strategy involved here in trying to cross-examine the people's expert regarding the reliability of the findings, that's the only way you can expose the evidence's weakness to the jury. If you don't conduct any cross-examination, then it just goes to the jury unchallenged as accurate and correct. Just by way of example, here at page at page 285, I'm sorry, at page 551, regarding these enlargements, which are diagrams with notes, and those parts of the autopsy report were enlarged. This is on direct examination, the people's direct examination at trial. This goes on direct examination for 5 pages. And for example, at line 8 of page 551, these are enlargements of Dr. Maloney's notes of the injuries and findings on Dr. Shada's body.
But that's not unusual, counsel, is it?
Well,
To enlarge a document so that the jury can read along with.
But okay, so if those findings constitute testimonial statements, then the point here is that Mr. Dyer was entitled to cross-examine the physician who made these findings. Dr. Hayes's conclusions are based upon Dr. Maloney's findings. His conclusions are only reliable to the extent that her findings are reliable.
In other words, you don't get to test the validity of the underlying
That's it, Your
examiners.
Honor. Yes. Thank you.
Thank you.
We do ask that the court hold its decision, that the better course here would be to wait for the Court of Appeals' decision on this issue in Ortega.
Thank you. Thank you both. U.S. Bank Trust versus Chung.
Good afternoon.
Good afternoon.
May it please the court, my name is Dan Chavetta, representing appellant Wendell Chung, and I am not here to argue this appeal. You probably know this, but after I submitted my brief, there was a change of law on the threshold issue of statute of limitations. And it turns out that's retroactive, which was a big surprise. And I brought this to the attention of my adversary.
You said?
Retroactive. It applies to any judgment that has not been enforced yet.
Yes, I understand what retroactive means.
Yeah, well, I thought you didn't understand my pronunciation of retroactive. Anyway, I brought this to the attention of my adversary. And we agreed, let's supplemental brief this. And so we submitted a stipulation that would postpone today's argument and allow supplemental brief on that issue.
When did you do that?
Well, we tried to do it yesterday, and the clerk bounced it.
Because, so then it doesn't exist. There is no stipulation right now.
Right, well, what I was saying is that we agree that this should be supplemental briefed, really.
Well, why don't you argue it anyway? Otherwise, I'm going to take it on submission. So I think that you should go ahead and argue.
Okay, well, I do have a letter.
And you can get your document to me as, do you have a letter signed by both of you right now?
I gave almost a final draft of this to him yesterday morning.
If you want to, you have time. I think you should use your time, and then I'll hear from counsel.
Can I submit this?
I beg your pardon?
Can I submit this?
Yes, submit it, and I'll make a determination as to whether I'll accept it.
You're required to cite contrary authority and hopefully distinguish it. And so in my brief, my initial brief, I cited the Engel case, which states that a lender can either wait until the mortgage matures, and he's got 6 months to sue if there's still no payment, or they can accelerate the debt. You have 6 years after that to bring suit. But if you accelerate the debt, bring suit, and then voluntarily discontinue, there's a reset on the statute of limitations. The new CPLR 312 subsection 4 abrogates that holding. There's no reset. It's quoted in my letter, and it's as clear as can be, in my view, that it makes this suit untimely because the debt was accelerated in April of 2008, and suit was not brought until May of 2014, more than 6 years. Now,
Counsel, just as to your letter, it's not signed and it's not a stipulation. I'm not going to accept it at this time. There's no, it's not signed.
We had a stipulation signed yesterday.
yes.
That we submitted to the court that was bounced back.
Then it doesn't, excuse me. I don't have, this is not a stipulation.
No.
This is not signed by you. I'm not accepting it.
Well, I can sign it now, and perhaps you can allow my adversary.
Counsel, I think you should just make a request after this argument. If you have anything further to argue on this issue, I would do it.
Okay, well, I can talk about the other issue in this case, which is that chain of title, but, you know, if the statute of limitations applies, then it doesn't matter. For that issue, I can just rely on my brief, and if there are questions after that, I can answer them now.
Are you withdrawing your appeal?
No.
So what's left?
Well, my position is that the statute of limitations argument that's in my brief is now a much stronger argument because of the change of law.
Thank you.
Your Honors, may it please the Court, my name is Arsenio Rodriguez. I represent the respondent in this matter. My adversary is referring to something called the foreclosure abuse.
Yes, we're FAPA, we're aware of it, 205A, which you're saying is retroactive, but I don't see that yet.
The statute itself referenced retroactivity, but it's been held in 2 matters, once by the Second Department and one by the Southern District.
That's not us.
Agreed.
Neither of those.
Agreed, Your Honor. I just wanted to make a point that counsel said that it's clear, and I think the only thing that's clear is that there's nothing clear about FAPA.
So then there is no stipulation here.
So I did execute a stipulation to brief this matter because my client would prefer to deal with FAPA. We didn't want FAPA to be in front of this court without our ability to do a brief.
Okay, so let me just, I'm sorry, I didn't reset your time. Let me just make clear that we are aware of FAPA, and if it's applicable, we'll apply it. But I think you should make your argument.
Agreed. So the first thing that I would mention, Your Honor.
As a matter of law, we could reach it if it applies, even if you didn't raise it specifically.
Understood, Your Honor. So then I'll just deal with the 2 specific issues that I wanted to deal with. In particular, the first one is standing. I think there's a confusion with respect to the brief itself from my adversary that you have to have possession and chain of title. But the standard is actually or. So if you have possession, then that's enough. If you don't, much like the case that was referenced by—
This was in blank, wasn't it? Wasn't this a note in blank?
It was endorsed in blank, attached to a verified complaint.
I might finish so that maybe you can short circuit. If you have the note in blank, and you don't have to establish how you got the note in blank, when you have a note in blank, you automatically have possession and can go forward. Is that your argument here?
That is precisely my argument.
Do you have anything to add?
Not to that, Your Honor. As respect to this statute of limitations argument, my understanding of my adversary's brief is that because in a prior case there was testimony about the choice to accelerate, that then in itself there had to be an affirmative act to de-accelerate that actual testimonial affidavit. However, Engel has since come out and said clearly a de-acceleration by voluntary discontinuance would suffice that affirmative act. So in that instance, whatever happened in that case, whatever happened in 2008, Once it was discontinued voluntarily, the deacceleration took place, and my client did not need to do anything additional as an affirmative act so as to deaccelerate that acceleration. If the judges in the panel have no further questions, that was my last point.
Did you finish?
Yes, I only had 2 points.
Thank you, sir.
Thank you.
The acceleration affidavit in another case was adduced in the record, and there was nothing to put in to rebut it, that it applied to this mortgage. To be honest, both sides could have made a better record in the trial court. And I don't know if you'll shut me up about this, but the retroactivity is in the text of the bill, not in the statute. Anyway, if no questions, I know this is convoluted, but we can go home now, I suppose. Thank you.
Okay. Thank you very much.